after the morning session, where we learn the definition of the problem, and we learn that it is affecting everybody, from the bank CEOs to the retail careful CEOs. We are now moving forward into the session number 3. Our next speaker is Sheikh Abdul Kareen inside Khadaied. He is a very humble person, and he is heading the Muslims Consumer Association in Malaysia. He is quite active there, and I would like to welcome him on stage for his speech.
We thank Allah for this. For His blessings to allow us to be this nice hall and after the risk that He has given us. We send our prayer and our blessings to Sallallahu Alaihi Wasallam. First, I am not the head of the PPIM. I am just the head of the Bureau of the Financial Monitoring Bureau. I stumbled on this before I joined the PPIM. I was a batik manufacturer for 30 years. Until one day Allah subhanahu wa ta'ala forced me out of the industry. And one fine day, I met this couple who have lost a job in the government service, who were bankrupt, and who had to resort being, really what is karangoni, I think. You guys know what is a karangoni. So they had a couple of children. They were involved in a project which is abundant, and they were being bankrupt. So both of them lost their job. And then I work as a karangoni. Husband became sick and has to be on dialysis machine every day. And he has passed away. And listening to the wife talk, I couldn't take it. It was then that I decided that this is going to be a project that I'm going to fight for. And it's that from that instant that this more and more research, more and more of such reports, more and such problems came about. So this is a summary of our work for the last 1.5 years. Now, how do I move this? Okay. I'm going to be very quick here because this is some statistics based on the cases that we have studied involving abandoned house projects of unlicensed developers. We receive both abandoned house projects, both licensed and unlicensed. I studied the unlicensed situation. Out of the 422 cases, we found that about 60% of them are with Islamic banking, and all of them are with PPA. So these are some figures. We got 16.5% where out of the 422, the houses were ready. The rest of them were not ready. Basically, this is the condition of the 422. The developer is not licensed. Land is agricultural. Developer did not have development license. And yet banks release payment. Especially in the case of Islamic banking. These are the parties involved. Your land offers, developer, your victims, lawyers, banks, KPKT, the ministry, Sharia Advisory Committee, you've got the banks itself and the panels of the Sharia panels of each and every bank. You've got lawyers, you've got bar counsel, you've got sales and purchase agreement, and you've got factory agreement. And also you've got, in the case of these unlicensed developers, we find that Islamic banks or banks, commercial banks, are involved in two forms of financing, i.e. as bridging financer and two as end financer. They were involved in bridging finance and they were also involved in end financing. All local banks, all, except one, Maybank, is not involved. Maybank is not involved, or I don't believe Ajit Mustafa when he said it's just simply because of luck. Because in the next question, he mentioned, Maybank plays a great importance to risk management. So I think he was being polite to say that it was luck. Okay, these are cases and the banks involved. Out of the 422, Bank of Riyadh takes 122 case, CIMB 144. Now in the case of CIMB, it's a mix between Islamic and non-Islamic. Muamalat 50, fully Islamic. Bank Islam 41, fully Islamic. Public Bank 42, also a mix between Islamic and non-Islamic. After Bank 1, and Bank 4, Persatuan National, IIUM. Now, we have taken out some statistics, some cases here, which originally we had. For instance, we had cases with Hong Leong Bank, but it's been taken out because it's been solved. There were 5 cases with Hong Leong, but it's been taken out because it was solved. Professional qualification, 70% are professional or semi-professional. Out of 42 average qualification, 70% of them either have diploma or above. %40 are bankrupt. I will deal with this later because this is one thing that we find very interesting. This is from Ustad Muhammad Nazri, Sharia Compliance Risk Management and Islam. Definition of Kahram. So, uncertainty and ignorance of contracting party over substance or attributes of the object of sale, or doubt over its existence and ability at the time of contract. So, if you're going to use that definition, there are a lot of issues there. Pay attention to assets. Does not exist, not free from encumbrances, not specified or not according to specification. Yeah? Not free from encumbrances. Alright? Now, tanah pertanian, agricultural land, meant to build housing project. Now, is that free from encumbrances? Okay, so the number issue is a serious issue as far as this is concerned. This is a state, just a summary. We find that at the time of signing the contract, the developers are not licensed. Land is agricultural. Banks are involved. Whether or not there is garau, the answer is yes. And then at the point of release of payment, whether or not the banks, the developers are licensed, no. Then still agricultural, whether or not this garau still exists, yes. We say yes, it still exists, because an unlicensed developer, how can somebody who does not have a driving license drive a car? This guy does not have development license, how can he build houses? Okay, I'm going to now go to my paper itself. I need help here. bear with me. Okay. Consumers who purchase a house do so out of necessity and the right, indeed, as in need of a financing mechanism. They have to choose whether they use Islamic or conventional financing. Muslims opt for Islamic financing mainly because these schemes are reported to be in accordance with the rule of Islam, the basis of which must be that it is fair, equitable to all parties concerned, it is trustworthy, and it admits and bears witness that Allah subhanahu wa ta'ala is the final judge, to whom we all must answer, and that all action must be towards obtaining the pleasure of Allah subhanahu wa ta'ala. These are the three conditions of what we would say to be Islamic: adil, amana, and for Allah subhanahu wa ta'ala. That in Islamic financing, the core concept is that everything belongs to Allah subhanahu wa ta'ala. That all parties, as managers, are responsible for the management of what Allah subhanahu wa ta'ala has entrusted to them. Hence, for consumers who look at Islamic financing do not merely look at the element of interest, but more so that they will be treated fairly and justly. For officers in Islamic bank are aware and bear witness that they are answerable to Allah subhanahu wa ta'ala. That within Islam there is security and peace. That all who work within the Islamic environment do so with the utmost dedication for professionalism, as work for Allah subhanahu wa ta'ala is part of ibadah. Hence, it can be expected that the level of professional and due care and fairness to be much higher than the conventional banking environment. The parameters of what is right and wrong must surely be beyond what the human court can determine what is right and wrong. Legally, we are advised by our panel of legal advisors that Islamic Banking Act has provision that Islamic banks cannot violate any rules of Sharia. That the Sharia advisory panel of each and every bank is duty bound to look at the operations of the bank so as to ensure that there is compliance with the dictates of Islam, not merely from the legal and technical aspects, but also the fundamental values of Islam. Also from the fundamental values of Islam. It is these fundamental values that are cornerstone of Islamic banking market. Any erosion of a section of this value will surely not only affect the market sentiment, but also the work of Allah subhanahu wa ta'ala, the anger of Allah subhanahu wa ta'ala. In the issue of garden houses, there are basically two categories: those done by licensed developers and those done by unlicensed developers. Due to the numbers of claims that we have received, we have studied cases involving unlicensed developers. As of July 2010, 58 companies, please ignore the slides, 58 companies that has undertaken housing projects that are unlicensed under the Development and Control and Licensing Act 1966 that were traced. One such company, Sheikh, for instance, have 48 projects with an average of 50 houses per project. Simple and Jomra has about 20 projects with an average of 100 houses per project. In the absence of official figures of exact number of houses involved, a fair estimate based on the number of known companies in the project, PPIM estimates between 150 to 200,000 houses were involved from 1990 to 2010. Conservative estimate should surely be around 100,000 houses. In most cases, these developers who are not licensed under the Act do not have development plan approval from the relevant authorities. Neither do they have relevant permits to advertise and sell. The land on which these projects were to be developed were mainly agricultural, and in most instances, land is owned by a third party who is not the developer. Let us now examine how consumers have been let down by professionals who are expected to do their job prudently. So now, I will now give you a summary of the 422 cases and what we have studied until today. After looking at the 422 cases, we have summarized our views on each and every party involved as follows. These views are based upon the facts and documents available to us. We have tried our best to be as objective as possible. However, when there are to be any factual error, we stand corrected. We are not Maksum. It is obvious that the bias, number one, the bias. It is obvious that this bias proposal should have been more prudent and higher to better and safer practices in buying houses. We are told of cases where sales and purchase agreement was signed in coffee shops and bank loans agreement signed in houses. We see people getting approval up to 6 houses with 6 different banks financing this purchase. Expediency and easy transaction seems to be the cause of lack of scrutiny on the part of most buyers. Having said that, as layperson, these individuals had a lot of faith in the lawyers, bank officers, and other professionals to do their job well. The state of these buyers today are generally as follows. Today, the state of these buyers are as follows. One, those who have been made bankrupt, who are either still employed, while others have lost their government jobs or have suffered loss of promotion or job opportunity. B, those who have been blacklisted and cannot get any form of financing or even open a bank account. And 3, those who have been paid some installment and therefore they are free. Majority of these cases that we handle are those who are merely blacklisted, with about 100 cases which are still bankrupt. The developer. We find that in the case of Shahira Group, that it was a very well thought of plan. The entire group of professionals were either linked to the developer or family terms with them. Raja Samsul, who is the main player in the Shahira case, is also the solicitor in a few of the sales and purchase agreement. The scheme to sell land and build houses were used in the case of Shahira Group of projects and that of IIUM, another housing project. The entire agreement, land sales and construction agreement, was done at the advantage of the developers, with the buyers only having little protective resource. The use of construction agreement, in our view, is merely a deception to go around the need to make it necessary to have a license. As proven in a 2013 judgment in High Court, that such projects are deemed to be housing projects and therefore fall under the preview of the Act. As far as Simpulan Cegulam is concerned, the schemes of things are not that well thought of as Shahira and REITs, but it was still well thought of scam. On the issue of the land purpose license, there are arguments that because in the case of Shahira and REITs, argue that there is no need for such licenses. Parties have entered into construction agreement. While in a sense this is true, in recent case, ABT Constructions Namrahat and Anwar vs. Tribunal Tuntutan Pembeli, the court decided that a developer who develops more than 4 houses at a particular site fall under the preview of the Housing and Development Act. As a developer involved in the sales of more than 4 units of the house accommodation, and therefore clearly within the definition of Housing Development Act. The use of the term contractor when developing more than 4 houses on a particular site, but entering into an individual construction agreement, must surely be seen as a ruse to go around the law, which in our opinion should have been noticed by bank officers. This is our stand. The bank officers who approve this financing to where the agreement was construction agreement, and then maintain that because there is no need for developers license. We are saying that they should have known better, just as much as Maybank had known better, and Maybank will not finance. Lawyers. The first group of professionals who have not done their job must surely be the sales and purchase agreement lawyers. We have seen quite a few judgments in court where such SMP were declared null and void. We are told because unlicensed developer cannot contract to build and sell the houses. We see that there are law firms who draft more than 5 construction agreements on one particular site with the same contractor. What we're saying is that the lawyer is aware that the same developer is developing 5 houses of the same development. Therefore, he should be classified as a developer. But he did, he still proceeded and proceeding with the sales and purchase agreement as a contractor. Second, lawyers financing. We see that insofar as lawyers acting on behalf of Islamic banks contracted with becoming agile, did not pay attention on the issue of capacity and capability of the developer to deliver the subject matter, which did not exist at the point of contracting. We have been advised that the pertinent issue in BDA is not merely whether the product exists, but whether it can be made to exist, as far as the case is in these cases. This statement is on the basis of a particular judgment in High Court, where Dato' Wan Zawab said, the possibility of the subject matter becoming a relative is of paramount importance. We are advised that there are doubts whether the products can exist, and these doubts are real, it would have made the contract void. As a consumer group, we find that the financing lawyer, among others, who are panels of the bank, should have raised this issue as an unlicensed developer, agricultural land, no development approval. This must surely raise serious doubt on the ability to deliver a house in a housing project. Surely, without approval of the relevant authority, development plans, how can a contractor coordinate licensing for road, utilities, and other infrastructure for the project? If he does not have a development plan, we were made to understand that certificate of fitness cannot also be issued when there is no development plan in place. This would make vacant possession cannot be given to the buyers. This can clearly be seen when in some projects contractors have finished the job in the project. But because vacant possession cannot be issued, mainly because land has not been converted, certificate of fitness has not been issued. We even have one particular housing project fully completed, but vacant possession not given, cannot be given. A few buyers in this project have been made bankrupt. Their completed house have been occupied by third parties who refuse to pay rent and move out. As such, we find that the lawyers who made the financing agreement, should have been more careful. Noted the issues of Tahrar, which to our mind is very obvious. Architects. We find that the drawdown process is very much dependent upon the architect's certificate. On examination, we found that in the case of Sipul and Jumla, document attesting that the certificate presented to the bank were forged. Here we found that the architect, who is still around, making police report and making statutory declaration that the architect's certificate given to the banks were forged. Reports were made by the architect and questioned to the relevant authorities. What has happened is that the bank were given photocopies of this certificate and payment were made with these copies. We do not see effort to cite the original of these copies. In the case of Shahira, we find that the signature of different certificates differ from one another. It is in this certificate that we see a lack of professional duty of care that banks usually exercise when they deal with, for example, documents for letter of credit, trade bills, or even examining documents relating to loan agreement for individuals. The usual high standards of document integrity, usually exercised by most reputable banks, seems to be missing here. Applying the standards of Amanah in Islam, we find this lack of firmness in checking documents of integrity appalling and shocking. Bank offices. Our legal advisors advise that there are sufficient provisions in the relevant banking acts to ensure that banks act prudently and with due care. We are told of sections in the Banking and Financial Act, BAFIA 1986, that banks cannot do anything that will harm the interests of the client or their a prospective client. We are also aware that when customers apply for financing facilities from banks, these banks will check with all relevant agencies for background checks. Bank will even insist on introducers to open account. Such diligence is applied upon customers who want to do business in the bank. It must surely be logical and fair that consumers will expect banks to exercise such standards in dealing with developers. Good prudent banking would necessitate that such practice in all aspects of banking operation. It is this prudent banking that we see Maybank practicing when they do not finance unlicensed and doubtful housing projects. Surely, Maybank, the possibility of profits from such financing cannot overrule the back business sense of financing something such an enterprise riddled with so much uncertainty. That financing illegal houses projects is not the right thing to do. Hence, the justification for Bank Negara's instruction in 2011 to all banks to cease such financing. Bank Negara issued a directive in 2011 to all banks to stop financing unlicensed developers. Such a directive to all banks must surely reflect the very negative practice of such financing. Bank Negara would not have instructed banks to stop something unless it is instrumental to the industry and to the community. PPIM stand firm and believe that if banks did not finance this development because they are either unlicensed without development plans on agricultural land, where conversion and subdivision may or may not be approved, this problem would not have happened. Banks who finance these projects knowingly enter into a contract where there are grave uncertainty. In the case of Islamic banks, it is our belief that the issue of uncertainty in delivering the house at the point of contract and the need for due diligence upon the validity of the claims of the developers before progress payment suggests the lack of professionalism on the part of the bank officers. Insofar as the disbursement to the developer for the cost of land, for the cost of construction, and we find that in most cases, although the banks extract from the developer and their lawyers letter of indemnity to refund whatever money paid to them, when and if such payments, the developers fail to deliver the subdivided land, or that the work is done and completed, we find that the bank have not taken action to demand from the developers and their lawyers refund for the money paid in a lot of cases. We find that the banks have proceeded to claim either the total disbursed amount or, in a lot of cases, SPA amount fully from the borrowers. Now, the individual bank Sharia advisory panel. That the duty of these advisors to ensure that the operation of the bank do not violate any rules of Sharia. Upon their shoulders lay the heavy burden of ensuring that the interests of lay Muslims, who are their brothers and sisters in faith, and the general public, are protected and respected. They are learned in situ. The question that begs to be answered would be, what is the ruling in faith muamalah in this case? Are the learned contracting parties responsible to ensure that there cannot be any violation of Sharia or Bahra, or the possibility of it, so as to protect his lay person brother in Islam? What is the duty of the more learned among contracting parties as compared to his brother in Islam, insofar as protecting the rights of his brother in Islam? To all Muslims, that all Muslims are duty bound to ensure that when contracting each other, that the interest and right of the other is protected by each other, that each give the other his due. Islam do not allow us to take advantage of the ignorance of our brother. What then is the duty of one who is more knowledgeable in protecting the interests of his fellow brother in Islam? Must the learner in the banks ensure the layperson is not advantaged by his own ignorance? Should Islamic banks contract in such conditions? Should Islamic banks contract in such conditions, where the possibility of the subject matter becoming real is in grave doubt? As an entity that has greater resource of knowledge, should the responsibility to ensure goodness, the core meaning of Islam, fall upon the banks? Should not the cornerstone of Islamic banking, salam. This issue of faith needs answers. Hence, PPIM sees this scenario just as another double standard on the part of the industry that has to be rectified, failing which public confidence must surely erode. Bank Negara. We see that there are reports made to Bank Negara before 2010, actually from 2007. What Bank Negara Malaysia have done was merely relay this complaint to the respective banks. In 2013, consumers have written, about 100 consumers actually, written to Bank Negara Malaysia to complain on the matter of the possible violation of BAFIA by the respective banks. So far, we, all the complainants, have not seen any evidence that there is any investigation, even though there have been issues raised and evidence given. In a meeting with PPIM about 2 months after other complaints were made, we were told that there has not been an investigation for possible wrongdoing on the part of the bank. Perhaps Bank Negara Malaysia believes that bank officers are not so. Judiciary. We have studied some cases in court where we see a possible tendency on the part of the judiciary to protect the banks. We even have a clear-cut case, yet the bank was winning, and even a senior registrar making a remark that she has to protect the banks. We have another case where a person was made bankrupt, even though the defense has proven that the subject matter does not exist. Never been built. Yet, and the action is faulty from the start. The judge simply refused to hear these arguments and ruled in favor of the bank. It would be fair, based on the reports and complaints the PPIM received, to say today the public perception is that the judiciary is protecting the banks. This is a public perception PPIM is relaying. Whether or not it is true, it is a perception. The burden of responsibility. The above general observation that needs further study and recapping. But what is certain, as of today, the entire burden of responsibility is solely borne by the consumer. Banks have refused to accept even partial responsibility that the officers could have urged that they have contributed to this sad state of affairs. Thus far, most banks are only prepared to reschedule financing. Only one bank, in one case, have taken a massive haircut and agreed to an amount of repayment that is far below the first amount. We are not aware of any other case where the bank have taken partial responsibility. What are the actions taken by banks? Number one, there are banks who only claim for whatever amount, only the amounts that have been disbursed. Only a small number of banks are only, we're talking about Islamic banks, claiming for amounts that are only disbursed. Second, banks that are claiming for SPA amount, the full SPA amount, even though construction of the house has not been completed or project never started. One case, $10,000 disbursed, claiming $600,000. With disbursed amount being far less than SPA value. In most cases, the house either not completed or just empty land. We have some cases that we can show you later. Clients have been made bankrupt based on SPA value. Argument that settlement amount would give IBRA on the account, even assuming that IBRA is computed to the net result only to the disbursed amount plus gross profit for disbursed after charging for SPA value is very wrong. You see, as a bankrupt, once he is bankrupt for say 600,000, he has to pay 12% to insolvency from the bankrupt amount. So if the bankrupt amount is 600,000, disbursed amount is only 100,000, and even the bank is to give a 500,000 IBRA, he still has to pay 12.5% from 600,000. What is happening? Most of these cases, they have appointed a third party to deal with to deal with the banks. But as usual, the banks have refused. I will deal with this later. What's happening is that all the 432 have appointed a consulting company to negotiate a settlement with the bank. Appointment of these consultants have been made in accordance with the relevant section of BAFIA. Thus far, except two banks, all Islamic banks do not recognize the right of buyers to appoint a party. Banks want to discuss on an individual basis. And when these buyers come to discuss with the bank, we see that the banks are only talking about risk handle, never about taking responsibility. We find that this refusal to recognize the right of third party appointed by consumer as a double standard on the part of the banks, as they appoint debt collectors. They sell NPL debt without showing sanction from the minister to allow the sales of such debt to such company. We find that the bank's refusal to recognize appointment is yet another sign that they do not want to deal with intelligent discourse to solve the problem at hand. We believe that the banks must respect the consumer right, just as they have the right to appoint debt collectors. Collectively, a detailed report is based upon each and every project. A total of 42 projects have been completed, examining technically, legal, procedural aspects. These legal aspects of the report have been written by a legal counsel, and the report can be used and will be used for settlement. What PPIM wants? What are our demands? 1. Starting point of all settlement should be based upon disbursed amount and lost profits alone of disbursed amount. Lost profits of disbursed amount. That all claims above disbursed amount plus profit on disbursed amount must be retracted and nullified. All such action should be rescinded, i.e., that all bankruptcy proceeding based on SPA amount, while the disbursed amount is far lower, must be rescinded, must be stopped and stand down. That the banks take responsibility where they have made mistakes and give discounts on disbursed amount. Where it is proven that the banks have made mistakes, they must take responsibility. When it is clear that they have contributed to the state of affairs, the buyer must also take part of the responsibility. The above is the case where less than 30% of the houses is being completed. A division of the percentage will have to be worked out. That when the cost of land has been fully paid in full and the land has been registered in the name of the buyers, that these buyers will have to pay in full the cost of this land and the bank profit, and thus acquire the land. In case where the property is 80% completed, a combined effort between the banks and the buyers will be undertaken to obtain white lines to complete the project, with financing details to be worked out. In cases where land or property has been registered to third party with bank consent, the bank should drop all original claims. In cases where the property is duly completed but CF not issued, then solution has to be found. In principle, these are possible pipeline of solutions that can be expanded and looked at. Of course, in all solutions, it is important that once an agreement is reached, all blacklisting and bankruptcy proceedings be lifted by banks and new financial schemes be put in place. Failure to find a just and equitable solution will result in total distrust of the banking industry by those who are affected, a loss of confidence in the system, as it has failed to give protection to the layperson. PPIM has repeatedly been requested to organize massive demonstrations against banks by these individuals, and so far we have managed to calm these victims. We cannot guarantee that we can do much more. We ask for good sense to prevail. We plead for good sense to prevail. I now will show you a few cases where these are court cases where full SPA amount has been asked.
Okay.
The last one.
PowerPoint finished?
Next one. The last one.
Okay. 5 more minutes, please. Okay. Because we
Don't give them some
Okay.
opportunity to answer.
Okay. First is the Pengguna case. Sorry, Prof, I have the name because these are already public documents. These are court documents, so it's a public document. Pengguna, this BPA is 234, SPA is 566. Disbursed around 99,000. Bank claimed initially for 547, but in particular, in a court case recently, they claimed for 460. And the judge affirmed that the consumer must pay 460. The court ruled. Yeah? Next one. Okay. Second case, Bank Muamalat. PPA 250, SPA 767, disbursed amount 77,000, amount claimed by bank in a court proceeding 766, i.e. judgment was obtained for 766. Judgment obtained, yeah? That means the court agreed that the customer must pay 766. Bank Islamic, same thing. Also, judgment obtained. RHB, also judgment obtained. So, it is not just the bank. How? Judgment obtained. I thank you.
Now we would like to open questions from the floor. 1 or 2 questions maximum.
Thank you very much.